Hello and welcome to this episode of Parley, the Hindu's weekly podcast, where we discuss pressing questions of public importance with insights from experts. I am Aratrika Bhaumik, your host for today. This week, we examine a critical question: do immigrants have the same right to protest as citizens? This debate has gained renewed importance following the recent self deportation of Ranjani Srinivasan, an Indian PhD candidate at Columbia University. She left the United States after Immigration and Customs Enforcement agents raided her campus housing allegedly over accusations of being a pro Hamas sympathiser. Similarly, on March 8th, immigration officials arrested Mahmoud Khalil, a prominent Palestinian student activist and green card holder, for purportedly violating his residency terms by supporting a US designated terrorist organization. To analyze the legal and as well as the foreign policy implications of this issue, we are joined by Dr. Prabhash Ranjan, professor at Jindal Global Law School, and Dr. Happymon Jacob, professor at Jawaharlal Nehru University and founder director of the Council for Strategic and Defense Research. Thank you so much for joining us today.
Thank you.
Thank you. Delighted to be on board.
Dr. Ranjan, if I could come to you first, starting off with the key question for this discussion. Under existing international human rights law as well as established state practice, do immigrants enjoy the same set of rights when it comes to the right to protest as citizens?
So, thank you for having me, Ratrika. It's a pleasure to be here along with Happymon. To answer your question, if you look at Article 19 of the International Covenant on Civil and Political Rights, which in a way codifies the basic international human rights law, and specifically Article 19.2, it states, and I quote, that everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing, or in print, etc. So, from this article, it's very clear that freedom of speech and expression is recognized as a fundamental human right, and this applies to both immigrants and citizens of a country. But at the same time, if you look at Article 19.3, which is just the next provision in the covenant, it also says that the exercise of the rights given in paragraph 2 carries with it special duties and responsibilities. And therefore, it allows the state to impose restrictions on these rights if such restrictions are necessary. So, in other words, or in simpler terms, I'll say that countries are free to impose reasonable restrictions which are necessary specifically for the protection of national security or public order. So, from this, we can say that while immigrants have the same right to protest as citizens, but there are certain restrictions which the host state can impose. And likewise, there are other provisions in the covenant which explicitly rule out any propaganda for war, or it explicitly rules out any advocacy for national, racial, or religious hatred, that leads to violence or that incites violence and stuff like that. So immigrants have the same rights as citizens to protest internationally. But what is important is that one will have to closely look at the domestic legal system of the country concerned. And some countries may have stricter laws on this, whereas some liberal democracies may have more liberal laws on things like right to protest. So while the international law provides us the broader framework, the actual implementation of this international law is still contingent to domestic law of the host states, and host states can restrict rights of immigrants if they think it is necessary in national interest.
Right, Dr. Ranjan. Also, follow up question to that. Under IHL, is it necessary for such restrictions, let's say, to be legitimate and proportionate?
Yes, they should be legitimate, not just legitimate, they should be proportionate and necessary. So, in other words, The state is under a duty to show that if they are curbing the rights of an immigrant in terms of speech and expression, it is necessary and it is proportionate. Necessity will be part of the proportionality analysis. You should not be doing something which is more than what is required to accomplish an objective. But then again, whether something is necessary, proportionate, who decides it, you will never or you will rarely get an international court to decide these questions. So these questions ultimately are decided by domestic courts. And in liberal democracies, the courts generally act as protectors of fundamental and human rights in this regard.
Right, thank you. Dr. Jacob, coming to you, what are your preliminary thoughts on the deportation drives and arrests so far? Also, to what extent should a nation's foreign policy and national security considerations really influence the right of immigrants to peacefully protest?
Thank you for that question. I think Prabhash made some very interesting points about the international humanitarian law. In fact, the overlay of the international humanitarian law and how that, in some ways, intersects with the domestic legal, frameworks that a country has adopted, through constitutional means. I think what happens, and there is a third aspect here, which is the domestic politics, which also Prabhash referred to in some ways. So you probably have to analyze this particular issue in the broader context of how what happens when international law or legal expectations meet domestic politics. I think that's the question here. I think things get complicated when international law meets domestic law, and it meets domestic politics, as it were. And that domestic politics may have international foreign policy applications. The point that I'm trying to make is that while legal approach to understanding this particular issue is one interesting and important way of looking at it, I think there's a larger political context that needs to be kept in mind in sort of understanding this. To sort of go to my second point, and that is about why are we really talking about what the Americans are doing, and whether that is right or not right, whether that is good or bad. I think it's because there is a established tradition in the United States of freedom of speech, or relative freedom of speech, as it were, right to protest peacefully, and there is therefore an expectation from the United States by the rest of the international community that the Americans will behave in a particular manner, and now the Americans have behaved in a particular manner. So I think it is this gap between tradition and expectation on the one hand, and the American actions on the other. That is why we are talking about this. So it is not really unheard of in other parts of the world, be it in Africa or Asia, even in Europe for that matter. You don't necessarily see a situation where non-citizens enjoy the same kind of freedom of speech in other parts of the world. I mean, our own country, or in other parts of Asia, or in Africa, things are somewhat different. I think if the right-wing regimes coming up in Europe, this is going to get more complicated in Europe as well. But I want to make one quick point before I hand it back to you, and that is about when you talk about a particular individual. I think immigrant is a broad sort of word here. I think the question to ask is whether this particular person is a citizen, a green card holder, and an illegal alien, as the Americans call it, or undocumented immigrant, or an illegal immigrant. What is the status of the person? So I think some of these conversations will have to sort of put through the test of the status of that particular person. If it is an undocumented immigrant, as it were, then I think the normal social contract that exists between a state or the government and a citizen may not necessarily exist in that particular case. And that's, I'm making a political argument, not necessarily a legal argument.
Right, Dr. Jacob, some very interesting points, and what you said is makes a lot of sense because we also have a green card holder here who has been detained. So that brings into question where domestic politics stand at the present moment. But before we venture more into domestic politics and what the framework in the US looks like, Dr. Ranjan, could you let us know what whether there is a First Amendment right violation when it comes to these deportations, especially when it comes to, let's say, detaining green card holders, as we have seen in the recent past.
Let me say this upfront, that no one should be deported merely for their political belief. But having said that, can someone be deported for their political belief? I mean, the answer is a little more complicated. Now let's take what is happening in the US. If we look at the chronology, we'll see that there is an order coming out from the US administration, and then the question of implementation of the order, and the questions that whether this order is constitutional or not. Now, I'll divide my answer in two parts. I'll say that if we look at the first part, that is the order itself. I mean, whether the U.S. president has the power to issue such an order. If we look at the U.S. law, specifically a statute known as the Immigration and Nationality Act of 1952. Now, this U.S. legislation specifically allows denial of entry and deportation of any alien who endorses or espouses terrorist activity, right, or who supports any terrorist organization. So, President Trump's executive order is based on this federal law, which means that in issuing this order, President Trump or U.S. administration haven't overstepped their constitutional authority. So that's one part to it. The second part is that whether this executive order itself is constitutional or not. So you may do something which the constitution or law may allow you, but you may do it in a manner which may be unconstitutional, and that is what the real question or real stuff here is. Now, it's important to look at the U.S. law, which clearly recognizes that it is not just citizens, even non-citizens, and regardless of their immigration status, they all possess the same First Amendment rights as U.S. citizens, right? So, and this is especially true when it comes to matters such as protection against criminal penalties, or criminal investigations or civil law enforcement. However, the complicated or the difficult question is that it is uncertain whether non citizens enjoy the same First Amendment rights as citizens in relation to the deportation process. Now, this is where, Happymon's point becomes very important, that we'll have to look at the legal status of the individual concerned, and go on a case to case basis. So, if, say, someone has or someone holds a green card, this individual would certainly have a stronger protection in comparison to someone who just has a student visa, right? So whether the First Amendment rights equally apply to the deportation process is a more difficult question to answer. You will find it interesting to know that in the past, and this was especially during the Cold War, there have been instances in the US where legal aliens were deported for their membership of the Communist Party, for example. So there is a track record of such kind of deportations taking place in the past as well. Of course, a lot of water has flown under the bridge since then, and the US legal system has become much more stronger and robust. But the legal status of the immigrant, I think, becomes a very important factor which will decide whether a particular deportation is legal or illegal as per the US law, and also as per the international law.
Right. Thank you, Dr. Ranjan. But for a bit of clarity for our listeners, what you're essentially saying is there is still a lack of clarity as to whether, when it comes to First Amendment right, whether an exception can be drawn with regards to an immigrant or a green card holder, whether if it supports a US designated terrorist organization. That is the defense that most of these US authorities are taking right now. So there's no clarity as to whether this would constitute an exception to the First Amendment right.
So yeah, so there is no exception to First Amendment right when it comes to protection from criminal penalties, criminal investigations, and all those things. For all those matters, there is no exception. I mean, whether you are an immigrant or whether you are a citizen of the U.S., you have the same First Amendment protection. It's only when it comes to the matters of deportation that some people have a stronger protection in comparison to someone else. So a green card holder will have a stronger protection in comparison to someone who is just on a student visa.
Right. Thank you, Dr. Ranjan. Dr. Jacob, coming to you, we have seen a series of stringent measures being taken by the Trump administration, It has cancelled almost 400 million in government grants for Columbia University, and has also made federal funding for universities contingent upon measures like empowering campus police to make arrests. So, do you see these measures deter Indian students now from pursuing education in the US, and how would it actually impact international students overall?
If I could spend one more minute on the point that Prabhash made, and then I'll come to the question if that's okay. The point that I think Prabhash is making is absolutely fantastic, which is sort of giving you the state of play as far as international humanitarian law is concerned. Then he's sort of coming to the question of domestic law. And then, he's sort of described for us the status of the citizen, status of the person in question will make a lot of difference, whether the person is a citizen, green card holder, student visa, or illegal immigrant. I think that distinction, I think, for our listeners is very important. And finally, how the courts are going to interpret that. Now, the courts are going to interpret that based on the charges being brought about by the executive. Now, here comes the important question of interpretation. How do you frame an issue? Now, an issue can be framed depending on who is in power, who is the executive, right? I mean, if you have a bunch of students, and I was in the United States last year, I went to some of these university campuses, saw these protests. Pretty peaceful, looked pretty peaceful to me. But if and Biden administration did not really bother too much with the protesting students. But you have a different administration, and therefore there is a different framing of the issue. You can look at the same issue, which is protests happening in university campuses, as an arena of normal politics, or you can look at it as a question of law and order, which is again a domestic issue, or you can look at it as a national security issue. And therefore, if you look at it as a national security issue, if you frame it as a national security issue, your response is going to be very different. If you frame it as an arena of or an activity that is coming under normal politics, your response is going to be very different. If it's a law and order issue, you frame it that way, then it's going to be very different. I think the framing of this has to be kept in mind, and who is doing the framing of it. In this particular case, in this particular case, you have the Trump administration, which has a certain view of the world and of its opponent, which is framing in a particular way. After all, national security issues are also about how you frame it, what you make of it. So I think the legality apart, the status of the citizen, of the status of the individual apart, there is also the framing question. Now, let me come very quickly to what it means for, say, Indian students or foreign students studying in American universities. I don't think this is going to have too much of an impact on Indian students studying in the United States, or the decision of the Indian students wanting to go to the United States. It would be a very a minuscule of the Indian students who want to go or are in the United States who might want to participate in some of these protests. So I think the curbing of some of these freedoms in the United States is not going to be a major a deterrent for Indian or other students from going into some of these finest institutions in the United States of America. Number one. Number two, there are clearly a lot of other places where these students would go, but to Europe or Australia and other places, or to, for example, Canada. So I don't think that's going to be a problem. Now, whether it will have an impact on the funding of the American institutions, and whether that will therefore keep international talent away from American university campuses, that's a valid question. Now, if that happens, that's going to be a problem for the United States. That's going to be a problem for a country which thrives on talent that is brought about by the immigration that happens into the United States. So I don't think this is going to be a major deterrent for Indian or other international students in that sense, precisely because I don't think the primary objective of students going there is to protest against the United States to begin with.
Right, Doctor. Right, Doctor Jacob. Some excellent point. In fact, that actually reminds me that I think a very important aspect is also to see how these proceedings, deportation proceedings, would play out when it comes to whether we'll see the judiciary being more deferential to the executive branch. Doctor Ranjan, if I could bring you here. So while I was researching for this, I realized that when it comes to the judges who are proceeding over removal hearings, they are essentially immigration judges, that is, administrative judges, and they are operating within the Department of Justice. And the Attorney General, for instance, can have them removed as well. So there's a lot of executive interference that we can possibly see as well. So do you see that as an important consideration here, Dr. Ranjan?
Yes, it can be. It is an important consideration. I mean, that is a bit of a problem when executive exercises so much control over these immigration judges. And then, as Happymon is saying, how the executive has framed the issue will definitely play a very important role, even in deciding whether the action is legal or illegal. I mean, let's not forget that at the end of the day, law and politics are not as divorced as we would like to believe. Judges, we would like to believe that judges work in a depoliticized courtrooms, but in reality, many of the courtrooms are actually heavily politicized. So the legal interpretation takes place in a particular political context, and this I don't think can be ignored. And this especially becomes important when the executive has so much control over these immigration judges. So my faith is not so much from the immigration judges per se, but more from the U.S. judicial system as a whole. That especially at the stages of appellate review or when an appeal is filed, there might be an independent review, an independent scrutiny of the executive action, which may then lead to a fair decision, a fair judgment being given. But for a immigrant who is caught into all of this, this process itself might become a punishment, and perhaps that is the objective. Who knows?
Right. Thank you, Dr. Ranjan. If you could now discuss a little about the specific provision under which Mr. Khalil has been arrested. A bit of clarity for our listeners here. The Trump administration has invoked a very rarely used provision in the Immigration and Nationality Act of 1952 to justify the arrest. And the specific provision reads that the Secretary of State has the authority to deport any foreigner if their presence or activities in the United States would have potentially serious adverse foreign policy consequences for the United States. Dr. Ranjan, I would like to come to you first on this. Do you believe that such a provision vests immense unchecked authority with the Secretary of State, and this could potentially lead to a constitutional challenge?
The short answer, Aratrika, is that yes, it does. It's an established legal principle, and this is true for all, or at least most common law systems or even civil law systems, that the arbitrary enforcement of laws which may appear to be neutral is also a breach of due process. So this principle, if we apply this to the situation that you are mentioning, we find that a rarely utilized statute is currently being used or applied to at least one, Palestinian political activist, and this may enter the realm of arbitrary enforcement, even if the law on the face of it appears to be neutral. The listeners would be interested in knowing that the U.S. Supreme Court, in a 2010 case known as Holder versus Humanitarian Law Project, in this case, the Supreme Court said that the mere independent advocacy or membership in a group which may be government designated terrorist organization is not a problem. So in other words, if I'm merely advocating the position of a particular group which the government sees as problematic or sees as a terrorist organization, mere advocacy, and I'm not doing anything beyond that mere political advocacy is okay, and it's part of protected speech under the First Amendment. So therefore, if the U.S. government wants to prosecute anyone under this statute, it will have to bring in much more evidence to prove that there is actual criminality or wrongdoing. Mere membership, mere advocacy of what a particular group stands for on its own may not be sufficient. So in the individual case of Mahmoud Khalil that you're mentioning, I don't know what evidence the U.S. government has, and it would really depend on what kind of evidence has and what kind of involvement it is able to show. But if Mr. Khalil is merely advocating a particular position taken by a particular group, that on its own is very much protected speech under First Amendment.
Right. Thank you, Dr. Ranjan. Dr. Jacob, coming to you on this, it's very interesting because if you see the provision essentially, uh, it's essentially students like Mr. Khalil, they're not being detained for per se their political speech, but because of US's foreign policy objective. So, do you see such a provision being weaponized against individuals the administration simply disagrees with?
Well, completely. I think as Ranjan pointed out, this is a great deal of authority vested in the government. In fact, the fact that this particular provision potentially serious, as you just read out, potentially serious adverse foreign policy consequences to the United States of America. Now, this is absolutely inherent. I mean, sorry, ambiguous. There is no clear, objective definition of what it makes what it means in terms of foreign policy consequences of the United States. You could bring in pretty much anything under the definition of this particular statement, because it is so subjective, it is so loosely defined, or there is no clear definition at all, and therefore that makes it a tool for weaponization, as you correctly pointed out. There is no doubt about that. But I think what I would be more interested in sort of proposing to you is that all countries have these kind of extreme laws. Take any country, and pretty much every country would have this kind of laws, which are meant for uses in extreme circumstances. But if a political dispensation chooses to use those legal provisions which are meant for extreme circumstances for a non-extreme sort of context, there is pretty much nothing that the others can do about it, unless and until the courts decide to step in, which again, because you have a very loose definition of what it means, what adverse foreign policy consequences for the United States means, the courts also may not be able to impose its will on the executive. And as Ranjan pointed out, it is also not a good idea to assume that the courts are going to be entirely depoliticized or non-political in this particular context. So I therefore go back to the point that I made earlier, which is um, the invocation of such rare laws is in some ways a function of the political context, the political executive in place, and the political framing of the issue. As they say, show me the person, and I'll tell you what provisions to use, or something to that effect. So I think there is no point in hair splitting the various provisions of the law in this particular case, because the law allows, in my opinion, for extreme measures to be taken in extreme circumstances. And whether it is an extreme circumstances, whether it is an extreme case, is a political interpretation.
Right. Thank you, Dr. Jacob. Coming to the last question for the evening, how do you see this impacting the US's foreign policy and also the Trump administration's relationship with India? Do you see the administration being more responsive to, let's say, India's concerns, or is it likely to adopt a more transactional approach?
I don't think this would have any implication or impact on India-US relations to begin with. If anything, I think one of the complaints that countries like India have made in the past has been that, listen, you must not try and impose your ways of looking at the world, or your sort of so-called morals or values or legal provisions to the rest of the international community. The rest of the international community have their ways of going about with their domestic politics. So you have no business to keep out. I think that has been the argument from the other countries. So if the United States behaves in this particular manner, they are going to lose the sort of moral authority to preach to the rest of the world how to behave and how to conduct their domestic affairs. So that, I don't think, will have any implication for Indo-US relations to begin with. But I think what it does for the United States and for its foreign policy in some ways is that it clearly is a case in which the American soft power will decline in the years to come. Its international standing will decline in the years to come, thanks to actions of this kind. The US will have reduced ability to tell the rest of the world how to sort of conduct their domestic affairs. The It could potentially, one can make the argument that this could potentially lead to a further decline in democratic ethos and liberal ethos globally. But in any case, imposition of the American style of democracy or American values on others is clearly not democratic in my sort of reckoning. But I think the real implication, in my sort of opinion, is the inability of the United States to build, coalitions or coalitions the willing around shared values, using the name of democracy. Say democracies versus non-democracies. In the question of Russia, Ukraine, the Americans use the argument that the democracies must stand together in order to fight against the non-democracies, which in this case meant Russia and to some extent China. Or in the Indo-Pacific, the Americans will make the argument that this is the coming together, Quad is the coming together of democracies. So if in the domestic American space, democracy takes a back seat, liberal values take a back seat, and the ability of the Americans to use that internationally to build coalitions for various foreign policy objectives is going to be far more reduced. So in some ways, I mean, it was always understood that the Americans would use sophisticated moral and liberal arguments to pursue their foreign policy. So perhaps the mask has come off. Now they'll have to probably talk to countries more directly rather than using soft power or other moral argumentation, as it were.
Right. Thank you, Dr. Jacob. Some excellent points. Dr. Ranjan, coming to you, any concluding thoughts, especially when it regards to how do you think these deportation proceedings will play out?
I think I completely agree with him that the biggest damage that this is going to do is in terms of denting US's soft power. I mean, US has been seen, rightly or wrongly, that it's a country that values rule of law domestically and internationally, that cherishes freedom and recognizes freedom of speech and expression. You can even, you know, burn the national flag, and that's part of protected speech and stuff like that. And this then plays a role in developing a liberal culture and liberal thought process all over the world. But if US stops doing this, and if US starts turning or weaponizing law in the manner in which it is doing, where it is targeting individuals whom it doesn't like, then in a way it validates the actions of several governments in many parts of the world who are actually doing this, and therefore it makes the whole world much more turbulent, and not a safe space for people to express their political opinions. And that, I think, is the biggest problem with what is happening in the US, especially if you look at the cross border impact of what is happening in the US domestic legal system. So I still have faith in the US legal system. It is a robust legal system. Whether one individual or one administration can turn it over its head, we'll have to wait and watch, and it will be interesting to see how these deportation proceedings actually take place.
Thank you so much, Dr. Ranjan. Thank you so much, Dr. Jacob, for joining us today. This was a very insightful conversation, and I'm sure our readers and listeners will feel the same way. Thank you again.
Thank you so much.
Thank you. Thank you so much.